for some. This is Ann Badmus, and welcome to Unlocking Global Opportunities Navigating Work Visas. Before we get started, I want to be sure that everyone who is on has the ability to hear. So if you are on the webinar, please put into the chat feature, yes, if you can hear me. Hi. Okay, if you can hear me, please put yes. Great, perfect. Okay, great. So I see some people are still coming on, but we'll go ahead and get started. So as I mentioned, I'm Ann Badmus, and I'm an attorney here at Badmus Associates, and I'm presenting to you information about U.S. work visas. So during the webinar, you can ask questions at any time. Excuse me, and the way that you do that is to use the Q&A panel, which is actually to the side of your screen or somewhere, depending on whether you're using an iPad or a tablet or a phone or a laptop. Look for the question mark bubble, and that will be where you would go to ask a question. So we do ask that you put those questions into that section because that will be easier for us to track and be sure that we answer all the questions that we receive. The chat feature that you have used is mainly if you are having technical difficulties or have some other question you want to ask that is not related to the webinar. Also, we ask that for confidentiality purposes, please ask your questions in a general manner. This webinar is sort of public. There, other people are on, and we do not want to reveal any confidential information. So please keep any personal details out of any of the questions that you ask, and just ask questions generally. So that we can have plenty of time to ask questions, let me move on and give you some background about our firm. For those of you who have not worked with us or are new to us, we are an immigration law firm that's helped thousands of clients since 1993. And we've been fortunate to receive recognitions for the work that we do in helping the immigrant community. Also, just to also let you know that this webinar is for educational purposes. It is one of the ways that we try to provide information to those who are interested in immigration issues, but it is exactly that. It is information and not legal advice, because legal advice would require us to speak with you directly and get more specific information about your background and your circumstances and your goals so that we can appropriately advise you. So look to this webinar and the information provided as just a starting point to give you some background and information to further understand or meet with an attorney who can further help you with what you need. So our agenda today is pretty brief, or not brief, but it's pretty simple. We are going to cover work-related visas and divide that up between temporary work visa options, and temporary meaning that, of course, there's a limit to the amount of time that you could have that visa, or there's specific requirements related to a work visa. We are going to go pretty quickly because we don't have a lot of time, but we're going to quickly go over these different types of work visas. And just to be clear, it's not comprehensive. There are some work visas that are not mentioned here that are potentially visas that some people could use, but they're very, very rarely used. So we're not really covering those. We're really covering those that are more typically used by most people who are interested in working in the U.S. And we'll also talk about green card options. So the green card options are, again, only related to work-related basis for actually getting a green card. So there are several ways that people can get a green card through their employment or through their business. So we'll talk about some of those ways. But again, it's not covering all the types of green card options that are out there. We're just covering the ones that are most commonly used. So let's move on to temporary work visas. One of the first ones that most people have probably heard of and is most frequently used is the H-1B non-immigrant visa. So non-immigrant meaning basically that it's temporary and that it is not permanent status. So a non-immigrant visa whether it's H-1B or any of the other types of visas, it allows a non-citizen to be employed in the U.S. But for H-1B visa specifically, you can obtain or get a H-1B visa that can be renewed for up to 6 years, sometimes further, longer than that if you have applied for a green card. But in most cases, the simple rule is that someone can hold an H-1B visa for 6 years. And very importantly, it is required that the visa is related to a specialty occupation, meaning that the work that you're going to be doing as the H-1B employee is considered to be a high-level specialty occupation that requires at least a bachelor's degree. And the other point to know about H-1B visa is that it is a employer application, so most of the process is done by the employer or the petitioner, as it's called. So just some basic facts about H-1B. As I mentioned, specialty occupation is the key requirement, so that the job that you're going to work in the United States must require at least a minimum of a bachelor's degree in a specific field. And so that is kind of key. And sort of an update that we have with respect to H-1B visas, that the government seems to be very particular now, or seeming to ask more evidence to prove that the job itself has a specific degree requirement. So for example, if the job says bachelor's degree and doesn't say what field it's in, then it's not going to be considered a specialty occupation. Or if the job has different types of bachelor's degrees that it will accept, the government might also question more or want us to prove exactly why those specific fields. For example, if we're saying for an IT position that will accept engineering, we'll also accept information technology or a computer science degree, we may need to prove exactly how those degrees are related to the job and what specific job duties are being met by that degree requirement. So it may even go as far as requiring us to provide a transcript for the employee or a course curriculum and relating those courses to that specific job. So it can be pretty complex. So H-1Bs is not a simple application, and that's why we're addressing it first, because it is probably one of the more complex types of work visas. But again, the key thing to remember is that if you're looking at an H-1B visa, whether you're an employer or whether you're an employee, is that we need to make sure that the job itself qualifies as a specialty occupation. And then of course, if it does, and if we do have specific requirements, then the H-1B employee must of course hold the actual or have the actual required degree in order to qualify. Another aspect that everyone should know about is that it does require an employee-employer relationship. So this is not a situation where an H-1B employee can be an independent contractor, or what we call a 1099 employment. You have to hire, for employers, you have to hire the H-1B employee as a W-2 employee, an actual employee and not an independent contractor. And of course, the employee must only work with the H-1B employer. So having the H-1B visa does not allow you to work for any employer. It only allows you to work for the specific employer. And it also does not allow you to work out on your own outside of that, or even in some cases, if you are interested in having a business on the side or something, you have to be very careful, even if it means investing in certain circumstances. You have to be careful that that is not going to be considered a work that is outside of your H-1B employment. But the other part of that is as an H-1B employee, you want to work with other employers in your field of specialty, then it is also possible to have more than one employer if each employer applies for the H-1B independently. So you can have what's called concurrent H-1B, which means you can have employer A have an H-1B and employer B also have an H-1B for you, so you can work with both employers at the same time. And finally, as I mentioned before, H-1Bs usually have a maximum of 6 years, where an employee can hold H-1B status. But typically, when you apply, or when the employer applies, you can receive up to 3 years of H-1B status. So if you're applying this year, for example, and you can request, and if this is your first H-1B and haven't used the maximum amount of time, or haven't used a lot of time on your H-1B, you can apply for 3 years starting 2024 to 2027, as a 3-year period, as an example. Now, a lot of times the question is asked, well, does that mean per employer, or does it mean total of 6 years? And it actually means a total of 6 years. So it doesn't matter if, it does matter, but if you worked for 3 years with one employer and then changed jobs to another employer, well, you only have 3 years left. You don't have another 6 years available to a different employer. So it is specific to the H-1B employee, where he or she gets a maximum of 6 years of H-1B status, regardless of what employment that they had. The exception to that is if you, and we can't really go into a lot of detail, but if the H-1B employee has a pending green card application, then it's possible to extend beyond the 6 years, assuming that they've not received the actual green card in hand. Another H-1B basic to know is that, especially for employers, is that the employer must agree to pay what they call the actual or prevailing wage salary, and of course pay the same benefits as they would for any other employee. So there cannot be a lower salary being paid to an H-1B employee than would be paid to a non or a citizen employee who is in the same occupation or the same position at the employer. Also, if there's any benefits, healthcare, any other type of benefits, that must also be offered to the H-1B employee. So the H-1B employee must be on the same level of any other, as far as benefits and salary, as any other employee in the company. What must be, the employer must be mindful of is that there is the actual or prevailing wage requirement. So the actual wage means that this is the wage that you typically pay to, let's say, if you have an engineer coming on board, an H-1B engineer, and you always pay $50,000 to any new new engineer that joins your company. Well, then if that amount is the same or is higher than the prevailing wage, then you have to pay that actual salary. So it's important to keep in mind that you don't want to pay an H-1B employee less than you would for any other employee in the same circumstances. However, you could also have the opposite of that. If you normally pay $50,000 for that position, but according to the Department of Labor, the prevailing wage amount, meaning that typically in your local area, most engineers are paid $55,000, then you will actually have to pay that H-1B employee $55,000 as opposed to the $50,000 that you normally would pay. So that is something that employers must keep in mind. Another basic fact is that if you are in a license, if you, the H-1B employee, is in a licensed occupation like a physician, or if you're a CPA or some other, not a nurse, but a technologist, medical technologist, if a license is required for you to actually practice your profession, then you must have that licensed in hand before the H-1B can be approved. And then finally, the H-1B visa can be full-time or part-time. So you do not have to have a full-time position. You can have a part-time position as well. I did see a question from someone about they can't hear the webinar. I think most people can hear. We are broadcasting, and if you can't hear, I guess I'll just put in information there. It must be the volume there. So let me just put that into the chat. So sorry about that. Moving on, regarding an H-1B employee, if the position does qualify for H-1B, it's important, again, as I mentioned, that the employee also have the required qualifications. And that usually is at least the equivalent of a bachelor's degree or higher. And sometimes if you don't actually have a degree in that field, you can still qualify if you have enough of a combination of education, training, or experience that can be determined to be equivalent to a bachelor's degree. So that would be something that an outside company would evaluate your background and be able to confirm that you are considered to have a bachelor's degree, even though you've never received an actual degree from a university or college. And also a reminder to put any questions that you have into the Q&A section of the platform. Now, what's also important and something that is coming up for those of you who haven't, weren't able to attend our last seminar, is the H-1B cap. So there, for those who are first-time H-1B holders, for example, those who are on student visa and wanting to apply for H-1B, or those who are outside the U.S. and never had an H-1B visa, or haven't had a H-1B visa for some time, you will be subject to what's called the H-1B cap. So what that means is that there's a quota of 65,000 new H-1B available every year, every fiscal year. And then there's also another 20,000 quota for those who have U.S. master's degree or higher. But typically there are a lot more people looking to get this H-1B visa than there are available H-1Bs. So this 85,000 or so visas is a very competitive process where the government holds the H-1B cap lottery, which is starting next month in March, for those who want to try to have a chance of getting one of these H-1B visas. This year's lottery is expected also to be as competitive as before. So if you are interested, or if you as an employer is interested in hiring or continuing the employment of an employee that needs an H-1B visa, now is the time to prepare for the lottery, which is going to be about a 2-week process. So feel free to reach out to us if you are considering that. But if you are not, one thing that people should be aware of is that there are exemptions to the cap, meaning that some employment and sometimes some individuals will not be subject to the cap, which means that they can apply, or their employers can apply for their H-1B year-round and not be concerned about the lottery situation. So that is what we call cap exemption. And there are few cap exemptions. One is cap exempt employers. So these are employers who can apply for H-1B year-round without competing in the H-1B lottery, but they have to meet specific requirements. So typically those who are institutions that are cap exempt are universities, colleges, and nonprofit organizations that might have some affiliation with a university or college, where they're providing internships or training for college students. So that is one cap exemption. Another cap exemption is if the employee is going to be working with a government research organization, or even a nonprofit that has some affiliation with a government research institution. And then finally, for those who are private employers who are for-profit, it is still possible to be cap exempt if you will have your employee working at a location that would be cap exempt. So for example, if you have an engineering project, I'll go back to engineering again, but if you have an engineering project where you will be, your employee will be working on behalf of a university for at least 50% of the time, then that would also be considered cap exempt. So those are ways to being cap exempt. Another cap exemption would be very specifically for physicians who are beneficiaries or who have applied for J1 interested government agency waivers. So if you are a physician, J1 physician who received a J1 waiver through a government sponsorship, then you would be cap exempt. You would never need to worry about the H-1B availability, and that carries through with that physician even after they have completed their waiver requirements. So just last thing is just to talk briefly about the H-1B application process. This is the only one where I'm actually talking about the process because it is a little more detailed than other processes. But the employer, as I mentioned, is the applicant for an H-1B visa on behalf of the H-1B employee. So the first step is to determine whether or not the job itself qualifies for a specialty occupation and whether, of course, the employee has that. Once that's determined, then the employer applies for a labor condition application, which is basically requesting from the Department of Labor an approval saying that the position does meet the requirement, the Department of Labor requirement, meaning that the position is going to pay at least the prevailing wage or the actual wage to that employee. So there are some other requirements there that can be pretty detailed, but that's the basic requirement, is that you get the labor condition approval from the Department of Labor, which typically takes about 7 days after application. And then once that's received, the H-1B petition, along with all the data and the qualifications, proving the job offer, proving the employee qualifications, all that is submitted with the I-129 petition, which is filed with the USCIS. So step four, the USCIS will review and make their decision. Sometimes they may request additional evidence, but once that's completed, then their approval or denial is issued. If approved, if the employee is not in the U.S., then they would apply for an H-1B visa at the U.S. Embassy. If they are already in the U.S. in a legal status, so for example, if they're in the U.S. in student status, then their status will change to H-1B on the first start date that's shown on the H-1B visa. So I just want to make clear that as oftentimes we get asked the question, do we need to get a visa stamp in our passport after receiving an H-1B approval? Again, it depends on if the individual is in the U.S. or if they're outside the U.S. But if you're in the U.S., you do not need a visa stamp. However, you will need a visa stamp if you want to travel internationally. So if you leave the U.S., in most cases, you will have to apply for an H-1B visa at the embassy before you can return using the H-1B. Okay, so next I'll just briefly talk about other hiring options. And I mentioned before about students. So student visas are pretty common in the U.S. where the student once completed their field of training or their field of degree, they get an optional practical training, OPT, which allows them to work in their field of training for at least 12 months. For those who are in STEM occupations, science, technology, engineering, and math occupations or fields, if you visit the ICE.gov website, there will be a list of occupations that qualify for STEM and get the advantage of an additional 24 months. So some students who graduate from U.S. universities will get up to 3 years of working with using just the OPT. But of course, beyond that, they will have to look at other options like H-1B or one of the other work visas that we will discuss. There is another H-1B visa, H-1B1, which is also requires a specialty occupation, but it's sort of a set aside for specific citizens of Singapore or Chile. So it is very limited. It's rarely used because there aren't that many applicants from those countries. But I thought I would definitely, put that information up there for anyone who is a citizen of either Chile or Singapore. An H-1B1 option can be available, and the competition is very low for those. So you're not needing to compete with typically compete with that very limited H-1B visa process. However, the H-1B1 is a little bit different from the H-1B in terms of the amount of employment or how long you can have an H-1B1. So initially, when you apply for an H-1B1, it's an 18-month period of employment. However, there's no limit on extension. So there's, unlike the H-1B, which only has 6 years maximum, there is no maximum time frame on H-1B1. So someone can be in H-1B1 almost indefinitely if they want it. Next, we'll talk about another specific E3, specific professional visa that only applies to citizens of Australia. And again, like the H-1B1, there's a huge quota which is never reached because there aren't that many people from Australia applying for this type of visa. But if you are an Australian citizen, this could be an option, an alternative to an H-1B, because there's really although the criteria is almost the same, the competition for E3 is very, very low. So there's no concern about whether or not you can even apply for the E3. But it is different in terms of the term of employment. So with an E3, you can have 2-year periods of employment, and you can continue to extend that indefinitely as well. The other advantage to the E3 as compared to the other H-1B1 and H-1B visas is that spouses of E3 professionals can work. So there's no restriction on their ability to work, whereas the other ones that we just mentioned do not allow work, with the exception of H-1B, which has a specific requirement. So we'll talk a little bit about that in a minute. As you can see, there's sort of a trend here. These are visas that are really limited to nationals of certain countries. So it may not apply to the majority of you on this call or on this webinar, but we do want to make people aware that there are options for those who do qualify. So there's the TN Trade NAFTA Professional Visa. This is only for those who are citizens of Mexico or Canada. And if their occupation is listed on the NAFTA occupations list, which is a pretty long list, it's not comprehensive, but many people could qualify if they are within those fields. For example, again, engineering, teaching in some aspects, some teaching positions, different medical positions, various dentists, that sort of thing. So, though by no means that's not the only occupations, but if you are Canadian or Mexican, then you want to definitely visit the occupations list to see if your occupation falls under that list. The advantage is, again, no quota. There's no limit to how many TN visas can be issued each year, so there's no competition for those. There are 3-year, like the H-1B, you can get up to 3 years of employment every time you apply. And unlike H-1B, you can apply forever. I mean, there's no limit on the number of extensions. But typically spouses of those who are on TN visas cannot work. And let me see. So next we'll look at the E2 visa program. Now the E2 visa program isn't necessarily what most would be considered a work visa, but it does allow, it is more of an investment type of visa for those who are, again, citizens of certain countries. So this list is a little more expansive than the other lists that I referred to, or other visas. But if you visit the this website that I have listed here, you can see the countries that are eligible or for the E2 visa. There are quite a few of them. So if you're from one of those countries, then you might be eligible for the E2 visa if you are willing to start up a business in the US. And so the investment in that is not, it must be substantial, but there is no specific limit or specific amount that's required. What you have to show is that the startup cost, whatever they may be, you can invest the amount of the startup cost. So for example, if the startup cost is $50,000, then you have to show that you can invest, or you have invested that $50,000 to start up that business or buy a business. It can be startup or buying a business, but you have to own at least 50% of the company. And you can also, if you are not the actual investor, you could also be an employee of an E2 visa E2 company. So what that means is that if the owner of the company is an E2 investor, and you want to work for that company and you have the same nationality as that E2 investor, then you can actually be hired with that company as a professional or a managerial position. So there are E2 visas that don't necessarily require you to be the investor. You can be the employee if you have the same nationality as the owner of the company, or the 50% or more owner of the company. The other good thing about E2 visa is that spouses can work. So spouses can automatically get work authorization there. So sometimes we have people who are interested in doing business in the U.S. and also interested in working outside of the business. So maybe one spouse can actually be the spouse who wants to work outside of the business would be the dependent spouse, and the spouse who's willing to operate the business will be the investor. So you can also consider that as an option. The next work visa is it is a work visa, but it's more specifically planned or expected in terms of training. So there's a J1 exchange visitor visa. This is usually applied for outside the United States for someone who is wanting to come to the U.S. and gain experience, work experience in the United States. It's very, very specific. There has to be a program sponsor, so it's not something where an employer can directly apply for a J1 visa. They usually have to either go through a process of being qualified as a program sponsor or reach out to many companies out there who will be program sponsors and guide them through the process of bringing someone here as a J1 exchange visitor. One thing must be noted is that there can be the 2-year home residence requirement, meaning that if that J1 visitor or trainee has skills that their home country needs, then they may be required to return back to that home country for 2 years before they can qualify for any other type of visa, like an H-1B or some other visa that they might want to use. So that's very important if you're looking at a J1 visa. Next visa is L1 transferee visa. So this one is for people who have worked outside the U.S. and are being transferred by their company to the U.S. to work in either a executive or high-level managerial position or in a special occupation or specialized knowledge position. So this will be the case where there is a multinational company, and it doesn't have to be a large company. It can be a company that you've worked for in your home country, and they want to start a branch, or they have a branch or a subsidiary in the U.S., and they want you to come to the U.S. in order to perform services here in the U.S. So what's required on behalf of the employee by the employee is that they must have been employed with that in the foreign business for at least 1 year within the last 3 years. So this is something that you have to show that you have that employment relationship with the foreign employer, and then the foreign employer will have to provide, pay stubs, tax records, different things to show that you have actually worked with them for those at least a year. And also you have to show that the position itself is a high-level managerial position, or that it is special knowledge that probably cannot be found very easily in the United States as well. So that is an option. Sometimes people will use that, in particular if they're not able to get an H-1B and they have had that employment situation for a year. It's easier to be able to apply for a transfer visa, an L1 transfer visa, because there is no competition for that as well, because there is no limit on the number of L1 visas that can be issued. Another advantage to L1 is that spouses can also work immediately. And then finally, with respect to temporary visas, the O1 Extraordinary Ability Visa, this one really is focused on the individual person's background to show that they have done very, very well and have been considered to be at the top of their field on a national or international basis, meaning that they have received recognition. So there are very specific criteria, which we don't have the time to go through. We'll have another presentation more specifically on the O1, but this is where the potential employee shows that they have met at least 3 out of 10 criteria to show that they have reached that international or national recognition. O1 allows 3 years of initial employment with unlimited extensions. However, dependent spouses cannot work. Then finally, before we go on to green card, I just do want to mention, as I've been talking about, dependent spouses, spouses of people who have H1B, E2, E3, L2, L1, or even J1. So spouses can work if you're in these categories, if you're E2 dependent, if you're E3 dependent, if you're an L2, which is a dependent of an L1 visa, and if you're a J2, which is a dependent of a J1 visa. There's opportunities to work. For the H1B spouse, typically there's not an opportunity to work unless the H1B principal employee has applied for permanent residence and has met certain requirements in that regard. So, for example, if the H-1B employee has an approved I-140 petition, then the H-4 spouse can apply for an EAD. So there's other requirements as well, but that is an opportunity for dependent spouses to work. So lastly, we'll go quickly through and then get to your questions. Definitely we'll answer your questions. Green card options. Again, we're going to talk about 2 or 3 options for green card through employment. The most typical option is the EB2, EB3 perm labor certification process. So this is for those who have a job, an employer who is willing to go through this process in order to obtain your permanent residence. So this is like the H-1B, an employer-sponsored application, which is designated for a specific identified employee. But the employer must go through a specific recruitment process to show that it has not been able to find any qualified U.S. citizen or permanent resident who is interested in the position that they're offering. So there is specific advertisement that the employer has to do before it can qualify for the EB3 perm labor certification. So the labor certification refers to certifying that there are no qualified U.S. citizens or permanent residents available. So to get that certified, the employer must do that recruitment. They must show that they also agree to and have the ability to pay the prevailing wage. So whatever is the minimum wage that the Department of Labor says must be paid to someone in that occupation. The employer must agree to do that, and they must show that they can do that. On the employee side, the employee must be qualified for the position. So if the employer says, I need a master's degree plus 5 years experience, as an example, for this position, then of course the employee must also have a master's degree and 5 years experience at the time that they file for the labor certification. And then finally, as I mentioned, it's EB2, EB3. So EB2 is for people who have advanced degrees, meaning master's degree or higher, or a bachelor's degree plus 5 years experience is also considered to be a advanced degree situation. So advanced EB2 is advanced degree positions. EB3 covers every other position, which could be professional, bachelor's degree professionals, or skilled or unskilled workers. But the perm process is essentially the same, regardless of whether you're EB2 or EB3. Where there's a difference is sometimes the speed of getting the green card depends on which category you're in. EB2 tends to be a little bit faster and a smaller waiting list or shorter waiting list than EB3. Okay. Next, we'll go to the national interest waiver. Quickly, we see a lot of interest in this. So the national interest waiver basically is a waiver of the perm labor certification process. So what that means is that you do not have to have a specific employer go through any advertising process for you. You do not have to, so actually you are the applicant, you as the employee or the person interested in getting the green card. You're applying on your own. And you can be self-employed or intend to be self-employed. So a job offer is not required. However, there are two types of of national interest waiver. One is what we call the general, which means it applies to any profession. And I'll come back to that in a minute. And then we have the physician national interest waiver, which is only for physicians who are willing to work for 5 years in an underserved area. So getting back to the general, there, like I mentioned, there's a lot of interest there. The basic requirement is that you have at least a master's degree or higher, because this is an EB2 category. So you have to show that you have the equivalent of a master's degree or bachelor's plus 5 years of experience. But the real key part of this is that you have to show that your work that you are doing or plan to do in the United States is in the national interest, will have national impact. So this means that beyond your specific job, others will receive advantage from your work, or the U.S. will receive advantage from your work. So, for example, typical NIW application is in research. Research is an easier example, because when you do research, you publish, and that, having published research, that information, that work that you're doing is now being disseminated throughout the world practically, but definitely throughout the United States. So if you're doing research in an area of interest like medical research or educational research or different types of research, there's no limit on the type of research, but if you can show that it's something that the United States would have interest in terms of benefiting the citizens of the United States in some way, then that potentially you can apply for the national interest waiver. But if you are basically working in a job and of course benefiting your employer, but it doesn't reach beyond that, then national interest waiver is not going to be an option for you. So it's very important to determine what is your proposal, what will you be doing that will have national reach in the United States. And the last thing we'll talk about before questions, so we'll have at least 15 minutes for questions, is the EB1 category. So the EB1 also requires some kind of benefit to the United States, although it's not necessarily having to show this kind of national reach. But what the government is interested in is those professionals who can show, similar to O1, that they have sustained or have had national or international recognition for their work. So if you're considered to be a well-known expert in your field and you meet the specific criteria, there's again about 10 criteria, and you have to meet at least 3 out of the 10 criteria. But you also have to pass what's called a final merits determination, where even if you do meet 3, or the government determines that you do meet 3 criteria, they still have to feel that you have received that national acclaim. So it is very subjectively evaluated. Right now, the approval rate is around 50% of the applications that are submitted. So you do have to have a lot of detail and really kind of overwhelm or try to persuade the officer that you do meet this criteria. The good thing about the EB1 is it is self-sponsored. You don't need an employer, but you do need to show how you will be employed or be able to work in your field of expertise, and what benefit is that field of expertise to the United States as well. So that concludes at least our presentation related to work visas and work green cards. Again, this is not it's not comprehensive. It doesn't cover all the options out there, but these are the most frequently used and considered options as well. So I will go ahead to questions. If you have a question, again, if you put it into the chat, try to put it into the Q&A panel. I will try to go back to it, but I'm going to focus first on those questions that are in the Q&A panel. So we have one question that says, are there any restrictions on how many minimum hours can an H-1B employee work on part-time only if they do not have a full-time job? So no, there's no restriction. Someone can have just a part-time H-1B altogether, no other H-1B, but a part-time H-1B. And that range of hours can be anywhere from 0 hours a week to 40 hours a week. And that's normally what we recommend if someone's doing a part-time H-1B, is to give a range of hours that can go from part-time to full-time. Full-time is, government considers full-time 35 plus hours a week as full-time. But if you don't know if you can work full-time with those number of hours, then part-time is an option where you can, your employer can list on the H-1B petition that you are going to work anywhere from 0 hours a week, because you may have not a fixed schedule. You might work every other week or something like that. They can say 0 hours to up to 40 hours, because if in the future they decide, oh, we do want you to come on full-time, they're not going to have to make any adjustments to the H-1B petition, because you've already covered a full-time schedule under that H-1B petition. So, but if you do have more than one employer, you can have H-1Bs part-time for 2 or 3 employers. You might have a part-time employer part-time employment under one employer. Another H-1B employer sponsors you for another part-time position, or you can have a full-time position with one H-1B employer and have a part-time position. And we even have seen some have full-time positions with 2 H-1B employers if they can work that much. So it's very flexible in terms of the time or the schedule that you have to have if you are doing a part-time H-1B. Okay, next question is, are a physician MBBS eligible for NIW if can work in a specific area? So if you're referring to the physician NIW, MBBS would be considered typically equivalent to a MD. The main requirement, though, is that you have to be licensed, of course, in the licensed physician in the state that you're going to work in. So if you are licensed and you have the USMLE and all the requirements for practicing medicine in the US, then yes, you can qualify for the physician NIW to work in an underserved area for 5 years. If you are not planning to work in an underserved area, and if you are more interested in research, then certainly as an MBBS or a physician, if you're doing medical research, you can also qualify potentially for the National Interest Waiver General Occupation, which is not clinical practice, it is research as well. Okay, hopefully that answers it. Next question is, you mentioned that J1 visas, you mentioned the J1 visa, how does that differ from the H3 visa? Yes, so I did not include the H3 visa, which is also a trainee visa. That is a different process, and it is more, there's more of a requirement for classroom training on an H3 visa. So the requirements are different, although some companies can more easily sponsor an H3 visa, which can be applied for in the US. With the J1 visa, usually the application takes place outside the US at the US Embassy for the employee that's coming in. They do have other requirements there that can be a little more difficult. You have to have a program sponsor, as I mentioned, whereas with the H3, you as an employer can sponsor directly. You don't have to have a program sponsor that has gone through a process with the Department of State to prove that it is qualified to help bring people here on a J1 visa. So H3 can often be a little bit easier, but it definitely would need to, provide the training aspects of that visa. The other part with H3 is that there's no 2-year home residence requirement ever apply to that, whereas the J1, there could be, depending on where the employee is coming from, what country they're from, there could be that 2-year requirement where they will have to return back, and it will be harder for you to, if you're looking at more permanently hiring that person, it will be harder to do so because of that 2-year requirement. Okay, next question. You said the employee of an E2 visa holder may qualify for an E2 visa if they're from the same country. Is that correct? Yes, that is correct. So if let's say someone from Germany owns a company here, they're not a permanent resident. They have either E2 visa, or they're just really the owner. They don't necessarily have to have an E2 visa. Because they may not want to actually come here and work. They may be just having a subsidiary here and kind of remotely managing the company, but they do want to bring employees from Germany to the US to work in the company. So those the E2 visa is an option for those employees depending on what kind of job they will be doing. So we do help people bring employees who are from that same country as the owner to the US. So yes, that is a possibility if you are working or planning to work for a company that is foreign owned, at least 50% foreign owned, and you are of the same nationality or same citizenship as the owner, then you can also qualify for E2. Without being an investment, you don't invest yourself, you're just an employee in that sense. Is there a time? Another question is there a timeline for an H-1B employer with filing the employee tax returns? So I think if you're talking about filing tax returns, I'm not quite clear what you mean with that. The employer does not file the employee tax returns. An employee files their own tax returns, but the employer, of course, has to issue the W-2 form, which generally the deadline for filing for an employer to issue a W-2 form is January 31st. So, for example, for 2003 work, the W-2 must, the 2023 W-2 must be issued by January 31st, 2024. Okay. So hopefully that answers the question, because I'm not sure if that was clear, but if you need to follow up with that, just type in the question again or type in more specifics on that. Next question is, what if for the E2 visa, what if the employee is already in the US, will they qualify? Well, it depends. Yes, they can already be in the US, but in order to change from whatever status they're in to that particular, to the E2 visa, they have to have been maintaining legal status. So for example, if you're a student on a student visa, and of course you've been complying with the student visa, then it's possible to change to E2. If you're here on a visitor visa, that would have to be done before your visitor stay expires. So you have to be sure that your actual current stay is in lawful status and that you apply before your status expires. Let me see, I'm going to go back to the chat because I don't see any more questions in the Q&A section, but I just wanted to be sure. I do see some people have not moved over their question, but I'll go ahead and answer those questions just in case. So, and these will be the last two questions. One question is, are nurses with degrees in nursing science eligible for this? I'm assuming it's referring to H-1B. And secondly, is it only for 6 years that the person needs to work, or can he or she continue to work longer than that with other employers? So if you're referring to the H-1B, which I think you are because you're referring to the 6 years, then sometimes nurses are eligible for H-1B. In most cases, they are not, because the government does not consider nursing as a specialty occupation, mainly because many nurses do not have a bachelor's degree in nursing, although that's available, but many nurses are hired without that bachelor's degree. So if the position is a typical RN position, which can accept an associate's degree nurse as well as a bachelor's degree nurse, then it would not qualify for H-1B. If the position, the nursing position is higher levels, for example, nurse practitioner, or which requires typically a master's degree, or if they are in a supervisory position, which requires a bachelor's degree, or if they're in a very, very specialized practice of nursing, maybe a surgical nurse, maybe not, but it just depends on if the employer can show that it is absolutely necessary that a BSN is required for that position, then it's possible to get an H-1B. But in most cases, it's very difficult. That the USCIS typically denies most nurse H-1B petitions. So there's a lot of risk there on that. But let's say if you are, to answer your second question, if you do receive an H-1B, that 6-year period applies totally to you as 6 years. It doesn't matter if you have one employer, 2 employers, 3 employers, or how long you've been with any employer. So for example, if you get an H-1B with one employer for 2 years or 3 years, and then you change jobs to another employer, you still only have 3 years left to have H-1B because you've already used three out of 6 years. So it is tied to the employer, and to you individually, not to the employer that you work with. Another question is, if one gets a visa stamp with one employer and before the stamp expires, if the new employer changes jobs, do they need to go back for stamping? So no, if your visa stamp is unexpired, H-1B visa stamp is unexpired, and you had that with another employer, you do not need to get another visa stamp in order to use that visa, the unexpired visa stamp. What you do need to do is, if you're coming back from travel using that visa stamp, you need to have your recent current H-1B approval notice with maybe your pay records and a letter from your current employer to present at the airports or at the border, so you can show them that you have a new employer. But that's, you don't have to have the stamp itself state the new employer. Of course, when your stamp expires, then you will have to get a new visa stamp with the new whatever current employer you have at that time. I did say 2 more questions, but we do have a little bit more time, so I'll go ahead and answer what few we have left. Next question is, if you are on visiting visa, how long does it take for the application process of EB-2 to be processed? Well, it's not that. If you're doing an EB-2 visa currently, you're on, and if you do get approved for the EB-2, for example, National Interest Waiver, EB-2, you are going to be on a waiting list because right now there is a backlog. So what that means is that you will not be able to do anything affecting your legal status in the United States through the EB-2 visa. You'll probably be waiting at least a year and a half based on our current time frame before you can apply for the second step of the process, which is the adjustment of status application. You have to have an adjustment of status application to finally get the green card, and that adjustment of status application is the process for you to change from being whatever status you're in to the green card. So if you're in the United States and you're on a visitor visa, your visitor visa needs to be extended for almost a year and a half if you're just applying. That's highly unlikely that will happen. So you will not be able to do anything in terms of extending your legal stay in the United States just by filing an EB-2 application. You will have to find another way to stay here, or you will have to return back and wait for your EB-2 green card process to be processed at the U.S. Embassy in whatever country you're in, or if you're able to come back again on another time on a visitor visa. And at that point, if you're eligible to apply for adjustment of status at that time, then you will be able to do it that way. But if you're looking more immediately to try to extend your status in the U.S., and you're currently on a visitor visa, an EB-2 visa is not going to help you. It's going to take quite a bit of time to get to that point where it will make a difference. Okay, I think I've already answered the questions here. So I want to thank all of you for attending. Again, my legal notice as an attorney is to let you know this information, even the answers of the questions, are informational purposes only. They are not legal advice. And so for your specific situation, it is best to meet with and reserve the time of an immigration attorney to really give you the correct advice for your case. If you liked our webinar, I'd like to ask a favor for you to reach out to us, visit our Google site, leave us a Google review, just Google Badmus and Associates, and you should be able to see our, whatever that site is called there for you to leave a Google review. So thank you again for your support, and I want to wish you all a wonderful day. Thank you.